I've been interested in functionality and expression in computer programs for more than 30 years of my life, and I kind of wanted to talk about other things, but the Oracle v. Google case has given me a heartburn, so I've returned to the subject of my youth. So we all know that conventionally copyright was supposed to be about protecting original expression and patent about protecting functionality. But we have, with computer programs, a subject matter where Congress assigned copyright to protect the most functional part of software, namely the object code. And so then the question is, what more abstract elements are protectable either by patent law or by copyright law? And today, especially in the aftermath of Alice, it's not clear what role, if any, the patents are going to continue to play. And one of the concerns that I have flowing out of the, what I regard as happy news, that patents aren't doing as much work on software, is that courts are going to feel like copyright has to step up to the plate. And that's actually some part of the explanation I give for why the Federal Circuit did what it did. So the question about whether there's any overlap in the protection of patents and copyrights is something that, again, I've been interested in for a long time, and unfortunately this case raises it again. So one thing we know, that if we're going to make copyright for computer programs mean anything at all, it's got to protect, generally speaking, source and object code, and to the extent that video game graphics look like movies and other visual displays are expressive in a conventional sense, I think there's no problem with saying that copyright protects that. The question about non-literal elements and to what extent is structure protectable and to what extent is these words procedure, process, system, and method of operation, to what extent do they to what extent should they be given some meaning, and how do you tell the difference between the structure that's a method of operation and the structure that's expression is a puzzle that I think is a deep and important one. So trying to sort of figure out what those words mean is actually a really deep problem, and Oracle v. Google does this. Now, the paper actually goes through each of the four main approaches in the case law so far. Whalen versus Jaslow has largely been debunked, and one of the things that I'm going to show is that, except in the Third Circuit, it's not really cited very often anymore because nobody thinks that it's really a good decision, except the Federal Circuit. Unfortunately. So one of the things that we see is the statement in Whalen that Section 102B's procedure, process, system, method of operation is just really a restatement of the idea expression distinction. It doesn't really have any meaning. Now, Computer Associates v. Altai did a lot of good work by basically saying there are lots of functional elements in computer programs, and there are categories of things that should be filtered out so that we make sure that copyright's not going to extend to functional dimensions of programs. But one of the things that I noticed, and it's pretty obvious, is that Altai doesn't say filter out procedures, processes, systems, and methods of operation, even though that's in the statute and efficiency isn't. So I'm curious about why that is. I offer in the paper an explanation for it, but I do think it's a deep problem. Lotus v. Borland actually does give some meaning to those terms, and unfortunately didn't actually connect up the Altai compatibility ruling, which would have made, I think, the Borland decision much stronger. But Section 102B is the highlight there. And then we have, in the Lexmark case, a merger of function and expression because the competing cartridges that Static Control sold chips for wouldn't work in the Lexmark printer without the Lexmark software loaded into it. Now, the district court in the Oracle v. Google case basically says that the command structure that Google re-implemented in Android software was a system or method of operation within the meaning of Section 102B. Says that Google used this to achieve some interoperability with other Java software, mainly relied on Lotus v. Borland and Sega versus Accolade. Kind of an interesting case because although it cites to Altai, yay, and repeats a lot of the things in Altai that says you've got to filter out a lot of stuff, it actually calls the interface a Section 102B type of procedure that's unprotectable by copyright law. So in some sense, the Sega v. Accolade case takes more the Lotus v. Borland approach by looking at Section 102B and trying to give an explanation there. The judge also offered a merger argument as an alternative ground for the decision, basically because the command names had to be identical if you wanted to achieve a degree of interoperability. And we see that the court is skeptical about this structure, sequence, and organization language, saying that since 1989 it's kind of fallen out of use. It's not really, doesn't help you to distinguish between those structures that are 102B excluded and those structures that might be expressive, and we want to sort of avoid the danger of granting patent-like monopolies through copyright. And to this judge, the API elements that were copied seem more like patent than copyright subject matter, although that's a pretty difficult thing to say too. Okay, so Federal Circuit, what does it do? It basically throws the merger argument out before others, basically saying that there's originality in what the Sun engineers did in designing the Java API because it was created at the beginning. Court basically says there's no compatibility exception to copyright, repeats dicta from the 1983 Apple v. Franklin decision that interoperability may be a commercial and competitive objective of software developers, but it's irrelevant to the question of whether something's copyrightable or not. And Section 102B, as in Whalen, is just a restatement of the idea expression distinction and irrelevant to this particular case. Google's arguments, they say, would make all software unprotectable by copyright law, and that's not supposed to be what we do. One of the most interesting parts of it is the court's recitation of the Mazur dicta that just because something's patentable doesn't mean that it's not copyrightable too, now seeming to conflate completely the subject matter of copyright and the subject matter of patent, which kind of seems like not the right thing. And one of the things that I show is the Federal Circuit should have read the whole of the Mazur decision, because in the next sentence after this, it basically says, copyright and utility patent, totally different game, but whatever. So one thing that actually I've learned that I think is really worth sharing is that there are several different types of compatibility issues that have been posed in these cases, and it's actually, I think, useful to break them out. So if you kind of think about it first, Computer Associates v. Altai case was one where you had two programs, scheduling programs, that were designed to interoperate with IBM operating system programs. The IBM operating system interface was sort of essentially the constraining thing for both Computer Associates and Altai. The Sega v. Accolade case, which comes very soon thereafter, is one where you have a platform and you have somebody wanting to adapt an application so that it runs on that popular platform. That's actually a different kind. And then you have the PlayStation game, right, the Sony v. Connectix case, where what you have is there are all these applications out there, and Sony makes a platform, and what Connectix does wants to make a platform that will interoperate with those games. That's actually a different kind of interoperability. And Borland is basically also an interoperability story because users had constructed these mini programs, these macros in the Lotus command language. And so in order to be able to allow those people to interoperate, with the Borland program, the command structure had to be in the same space, and I'm not going to say the other two, but you can see that there's just different kinds. Now, the compatibility issue in the Oracle v. Google case is of a different sort. At least it's partly of a different sort, and that's because of this. So the district court says that there are millions of lines of Java programs that can at least be executed on the Android platform and therefore be partly interoperable. And so that's an interoperability type of thing that's similar to the interoperability in Borland. But the big question in the case, and this is the harder problem, is the human interoperability story that's there. So to the extent that what you have is 9 million Java programmers in the world know how to program and use certain commands in the Java language. They express themselves, and they've written millions of lines of codes using those particular command names. And now Oracle says you have to Google. You can still speak in Java. It's just that you have to speak in a different dialect. And you have to teach all those 9 million people to use your dialect, not our dialect. And the question of whether human interoperability ought to be taken into account in the scope of copyright, I think is a really interesting problem. Judge Boudin, in his concurrence in Borland, basically does suggest that weighing the interests of those third-party programmers, so maybe not all of their Java programs will interoperate on the Android platform, but at least some of them will, and the ones that don't can be adapted more easily to run on the Android platform if they want to do that. So is the question of that kind of interoperability one that copyright should take into account or not is a really interesting one. So APIs, in the interest of time, I'm not going to go into them too much, but here is actually the example that Judge also put into his thing. So look at the method header here. So what Google did is it re-implemented in independently written code 6,000 method headers of the sort that's listed here, and there's a kind of standard format for these method headers, and this is the one that basically is a specification for the interface in Java for comparing two numbers and figuring out which one's bigger. Is that math or is that poetry? I think it looks more like math to me, and math, of course, is the method of operation, which is exactly what the district court said. These are other expressions of the Java command for this particular API. But you kind of look at it and you sort of say, copyright subject matter, patent subject matter, both or neither. I would argue neither is probably the right answer to the question, but what we have is sort of a difficult conundrum for the courts to grapple with, because it looks a little bit more like copyright because it's in words, even though words can sometimes be part of the system too. So I talk in the paper a lot about this idea of categorical exclusivity. Things belong either in the patent bucket or the copyright bucket, and there's no kind of cross-bucket character. And so that's certainly what Baker taught, but the Supreme Court in a couple of other cases has not been very happy about categorical exclusivity type of arguments. But I think the kind of argument that should be taken into account in these software cases is one that's like the Traffic's decision, right? So the Traffic's case was one in which somebody had an expired utility patent on a dual spring designed for signs, so that and you're in a place where the wind blows a lot, that it will kind of like bounce back up after a while. The expired utility patent, then the claim is that it's trade dress, but the patent described the functionality of the spring, and so the court said, I'm not going to say because there was a patent that it can't be trade dress, But let's look at the patent and let's see what the patent says about why it performs in this particular way, and it's strong evidence that it is that it's functional subject matter. And since there are lots of API patents out there, we might want to take a look at them and see what kinds of things are being patented. But of course, software patents are being eroded after Alice, and is that a good thing or a bad thing? I think so, yes. But I actually, my theory about why the decision came out the way that it did and was written the way that it did is because Judge O'Malley, who wrote the opinion on Oracle v. Google, was going to uphold all of the patents in the Alice case. And she's kind of like, I'm damned if copyright's going down on my watch too. Especially since the Supreme Court's gutting patents, I'm not going to let that happen to copyright. And so gave a very expansive interpretation. But the question I think that we really should be grappling with, and my paper is really trying to do this, is if in fact patents are shrinking now, does copyright expand to fill the gap? I don't think that's the right thing to do, but I do think, boy, it's a big problem. So part of what I'm trying to do is say, can you separate function and expression? The answer is no. In software, you can't really, it's turtles all the way down. So I think you have to develop a set of proxies and also put things in some context. So basically, I think copyright does most of the work protecting program code and expressive screen displays. Maybe there are some non-literal elements of programs that should be protectable expression. I'm agnostic about that. But most of them probably are excludable as procedures, processes, systems, and the like. I think program, functional behavior, languages, interfaces, logic, and algorithms are all things that categorically should be excluded from copyright protection. And I think if we adapted the all-type test to exclude section 102B elements, that would be a good thing. Another thing to kind of keep in mind is that copyright doesn't have to do all the work because actually software developers rely on trade secrecy and licensing a lot. First mover advantage is more important than many other kinds of things. And so copyright doesn't have to do all that work. I rest my case. So I think I have 4.5 minutes for Q&A. Yes?
Could you just say a little bit more about the level of abstraction problem? Because how you define what the function is may affect whether you view this as expressive or not. Yes.
So I think if you kind of take copyright as having this kind of, right, this is where the expression lives, and this is where pure ideas are. There got to be something up here that maybe secrecy can protect, but maybe not. But secrecy does most of the work in this space, and maybe copyright does a little bit of work in here. But I think that what we'd like to be able to do is say, this is where patents live. This is where copyright might, unless 102B, or efficiency. And things that are down here and are more concrete, specific, and detailed may still be structural elements of programs. But that's where, to my mind, if any of the non-literal elements of the program should be protected by copyright law, is down in this space, not up here.
So, let's talk about it for a minute.
Oh, I love that.
Right? So are you mad about the outcome, or are you mad about the language where the court said the only idea is the ultimate purpose of the software? I mean, in the actual case, they took the software and simply translated it line by line, command.
No, that's not true.
That's the way the court sort of comes at it, from one language to another. Do you think that ought to be infringement?
So I think that it would be interesting to have a Whalen versus Jaslow case after the adapted all-type test that I am talking about. So One thing I'm quite sure about is that the way that the modules operated was simply a software implementation of a business process. Remember that Jaslow, the guy who's the defendant in that case, actually ran a dental lab. He had to teach Whalen how to think about, right, how to structure things in order to be able to essentially computerize his business methods, his file structures, and the like. So I think if you went and looked at the case, that there are probably some efficiency elements in the design of the file structures and data structures. That's actually file structures, data structures, overall structure, and the modules. I've never been convinced that that's actually a good infringement case. But if it is something that's convincing, it's got to be, from my standpoint, printed down in this case.
And then can you help us contextualize or conceptualize your understanding of the relationship between efficiency and processes, methods, and the rest?
Yeah, so I see efficiency, I think, as a Second Circuit did, as a merger issue, right? So that to the extent that there may be a multiplicity of ways of doing it, but in fact, there are more efficient ways and less efficient ways, and one of the things that you don't want to do in copyright is force programmers, second-comers, third-comers, fifth-comers, to use less efficient ways of doing something. So efficiency narrows the range of choices. Now, one of the things that Baker v. Selden does, and I think some of the merger cases do as well, is that if you think about the adoption of the Selden bookkeeping system, right? Once you adopt the system, then anybody who wants to use the same system is basically going to have to use something that's pretty darn similar. So Baker didn't use exactly the same thing, but he used some elements of it, of the structure and organization of the forms. But if he wanted to be able to practice that, the form similarities were necessary incidents to the ability to reuse the system. So I think merger and 102B I'm finding a set of about a dozen cases where they're interchangeable, where you kind of accept that once the system or method of operation is unprotectable, then the range of choices for anybody else who wants to express that same system are constrained, and so merger is not that far away from this. Oh, good.